Evangelist. I do mostly constitutional law and civil rights work, some dealing with charters, which is the topic for today. What is the Clallam County Charter in the context of the United States legal system? So thank you for coming. Where do we start? Well, let's start with today is an anniversary of an important charter. Who's been following the news?
Yeah.
The Magna Carta, right? So, I mean, going back 800 years to today, or perhaps it's already tomorrow in Great Britain, so tomorrow, yesterday. So 801 days old is this, one of the first charters, this idea that, the rulers don't have absolute power, and they have to have rules and follow rules. That's kind of an origin for what we're going to be talking about here with local charters. So what I'd like to do is perhaps maybe start 800 years ago and kind of come up to the present with some history to give us the context for where the charter sits within the U.S. legal system, and then get into some of the details about how the charter interacts with other parts of the U.S. legal system. So this handout is a chart, and I made basically 3 columns. The left is constitutional, the center one is legislative, and the right one is regulatory. These are 3 kinds of law that happen in the U.S. legal system. And so then I made along the rows local laws, state laws, federal laws. So we're going to be looking at the constitutional local law for Clallam County, which is the Clallam County Home Rule Charter. But we have to understand that in the context of these other parts of the U.S. legal system in order to figure out, well, what can we do, what can't we do within our local charter. Does that sound okay to folks? Did anyone come for anything specific, any particular questions or that sort of thing?
I just really want to know what Washington state law says about charters and what they can do and what they can't.
Go talk to a court.
Yeah, go talk to a court, right.
Yeah. So we're going to be talking about some pretty complex areas of the law that yet affect basically the fundamental things we do, which is government that makes laws. And yet it's sometimes very confusing as to whether government can make a certain law or can't make a certain law. So I hope to provide a framework for thinking through some of those issues. But I have to say, at the end of the day, it ends up going to a court, and it's a question, and the rules can really go one way or the other on many issues. Sometimes it's very clear, and we'll try and figure out, well, when is it very clear? But other times, it's pretty confusing. In Forks, we talked about the marijuana law for Washington State. And I did a little bit of research today before coming here because I'm sure somebody wants to ask about marijuana law. And it's currently at the courts as far as what local governments can do or can't do. And so far it looks like the decisions are local governments can ban through zoning marijuana dispensaries and various other licensed marijuana distributors. But that might be changed depending on what the court's saying as it's appealed up. So we'll kind of skip the Magna Carta, but the Magna Carta was a charter, kind of a constitution, basically a limitation on authority. Skipping 500 years, 400 years later, we have settlers in North America saying that we should be able to govern ourselves. And the king is not letting us make the laws that we need to make to protect our health, safety, and welfare. That's kind of a basic function of government, and it's not working because the king is vetoing laws or not preventing the people from making laws. That's basically their first grievance in the Declaration of Independence, setting forth this idea that is not really a new idea, but is emphasized even more at that point that it's the people who constitute government, and the people set the scope for the authority of government and what government can do and can't do, and the people need to have that power. Otherwise, government is illegitimate, and then in the Declaration of Independence they say, and then it's illegitimate government the people have responsibility and a duty to abolish it and constitute new systems of government. The Declaration of Independence isn't really law in the United States. The U.S. Supreme Court hasn't said that yet, but a lot of other courts have. But that framework is kind of where we come from. And I think for many people, if we say, well, Declaration of Independence isn't law in the United States, you'd say, well, whatever, right? Like, you know, those are kind of foundational principles that we work from. So during that time, there was the Articles of Confederation, kind of the first Constitution of the United States, and then the second Constitution of the United States. But before getting to the federal constitutions, we need to stop and look at what the states were. Because when the states left Britain and declared their independence, they set up their own constitutions. The first constitutions in the United States are not the federal constitutions, they're state constitutions. I think Massachusetts is the oldest constitution in North America, and maybe the world at this point. I'd have to double check that. Please come in and join us.
We have every intention of doing this. Neither of us is timid.
So there was this breakaway from Great Britain, right? And in Great Britain at that point, people had segmented power between Parliament and the King. And so you know, the King had authority. Where did his authority come from? It came from God. And so then, you know, the people in the United States said, no, ruler's authority comes from the people. So that was one of the changes. But then, I mean, the other change is that, you know, it's not the King who has that broad power, but it's now the states, right? So it's the people, you know, giving their authority to the state in order to rule. And so the state legislature becomes basically the body that has all the power. And, you know, depending on how we want to look at it, really there was this bifurcation of power in Britain between the king and the legislature. And then when that framework came to these new states in the late 18th century, that bifurcation in some ways was lost, right? And that the state legislature became the body that had all the power, short of the power that the people reserved for themselves or specifically delegated to other bodies. So in the original state constitutions, and in mostly the framework that we still have, is that a constitution provides limitation on state government. So without the state constitution, the legal theory is that state legislatures basically have the power to do whatever they want. It's the state constitution that limits that authority or separates that authority between different bodies of government. So the theory is that the people hold the authority, but in terms of actually governing, we've given that authority to the state legislature. We've confined that authority in certain ways through the state constitutions. And we've also delegated specifically who in government has that authority. I'm going to pause there because that's like, it's kind of heavy stuff. We don't talk about state constitutions very often, and we don't think about what a state constitution means. And honestly, a lot of lawyers don't either. State constitutional law is an elective. Constitutional law, what like every lawyer takes, is all about federal constitutional law, not about state constitutional law. So those are the states. You know, they have this power. They then, well, certain people kind of, you know, what we could call now like the 1% got together and said, well, we want to create kind of a federal overstructure for that. And that out of that came the second U.S. Constitution, the one that we have now, right? So the Constitution of the United States created this federal structure. The framework is the states have this power. The states gave up certain powers to the federal government and then lost the ability to govern those areas themselves. So state constitutions and state governments, well, state governments are governments of plenary power or broad power. Basically, the power to make any law that is in furtherance of the health, safety, and welfare of the people. That phrase, health, safety, and welfare, is kind of a term of art in the law. It used to be health, safety, morals, and welfare. You know, we kind of dumped the moral part of the phrase, but that's kind of where it comes from. If the state wants to pass a law that is in furtherance of the health, safety, or welfare of the people, over at City Hall.
Are they open?
Big George building.
Well, not, no, I don't.
No, they're
Well,
not
they're
open
The
now.
police department.
Or 911.
I don't know, I've tried to go there on Saturday and it's not open, so.
So state governments are these plenary governments. They basically have the power to pass any law they want, as long as it's not limited by the state constitution, or it's a power that's been given up into the federal system, right? The federal government, on the other hand, is a government of limited power. So Congress cannot just make any law in furtherance of the health, safety, and welfare of the people. Congress can only make the laws that the US Constitution says Congress can make laws about, like taxes, spending, commerce, the post offices, military, what's all that stuff? It's in the articles of the US Constitution. It's a list of things that Congress has the power to make laws about. If Congress tries to make a law that is not one of those things, or necessary and proper to do one of those things, then Congress is acting outside of its authority. So if we think about one of the kind of big acts of Congress in the last couple of years, which is the Affordable Care Act, one of the first legal challenges against the Affordable Care Act was the claim that Congress was acting outside of its authority. And it went up to the US Supreme Court. The US Supreme Court said, well, for the most part, Congress was acting within its authority under, I think it was mostly the tax clause of Congress's authority, right? I see nodding, so yeah. But there's this one provision, that one about insurance for poor people, and that was definitely outside Congress's authority. So that part's gone, but the rest of it is okay. So the first challenge to an act of Congress is, well, did Congress even have the authority to do that? Because Congress is a government of limited power. And then the later challenges are, well, does that violate a constitutional right that some other person has? Right? When we're talking about an act of the state legislature, because the state legislature is a government of plenary power, most people don't bother challenging whether the state government had the power to do it in the first place. Because the test of whether it is in furtherance of the health, safety, and welfare of the people is a pretty easy test to pass, right? Like, it's basically kind of, you can say almost anything is in furtherance of the health, safety, and welfare of the people. So most of the time, if somebody's not happy with the law that the state legislature passes, they don't bother saying it's outside the authority of the state legislature to pass that law. Instead, they say, well, that law violates someone's constitutional right, or it's been delegated to a different branch of government, or maybe it was a power that was delegated to the federal government, and therefore the state government can no longer touch it, stuff like that. But there's an important distinction there between the state as having plenary power and the federal government having limited power. Is that okay for now? Yeah. All right.
So if we don't like the state government, we have to move.
Or change
We
it.
can't change it, we have to move.
Well, no, we can. So we have a state constitution. And the state constitution is a limitation on what the state legislature is able to do. So an important decision right now is around the right to education that's in our state constitution. So in the state constitution, the people of Washington said, we think education is really important and it should be supported. The state legislature said, oh yeah, we like education too, but according to our state Supreme Court, the state legislature hasn't been doing what it needs to do to fulfill that education requirement in the state constitution. So that's led to a Supreme Court decision that you'll hear in various city meetings and state meetings, McCleary, and the McCleary decision and how awful this McCleary decision is. But that is basically the people of Washington saying, we think education is important, we're going to put it in our state constitution, and the state Supreme Court looking at the issue, because people brought a case to the state Supreme Court on it, and the state Supreme Court said, yeah, this is in the Constitution and the legislature needs to follow it because the Constitution directs the legislature's power, right? So it's an example of, I think we as the citizens of Washington need to say, this is our Constitution. If we don't like what the legislature is doing, we can go over their heads, so to speak, and change our state constitution. That is very difficult at the state level because you have to get the state legislature to agree to change the state constitution. So there's a lot of questions about, well, do we still have that authority, that fundamental, governments of the people, when our state representatives have to consent to changing the Constitution? That's an important question, and we can talk about that for a long time.
So you can't propose an amendment to the initiative process from the people?
Not in Washington.
But other states have given people the right to amend their constitution? Okay, so, okay.
Yeah.
So you can't amend the Constitution because it's not in the Constitution, and you can amend the Constitution.
Right, so it's an interesting, one way that I think about this is often with agency law. Agency is this idea of a principal and an agent. The principal is the one who has the authority, and they give some authority to their agent in order to do certain things within the scope of their power. And that is really the framework we're talking about when we're talking about the people and government. Government is our agent, and we've set the scope of power for government to act within. Agency law is more often used with employees. The employer is the principal, the employee is the agent. And that's more often the framework, but I think it's a helpful framework for thinking about government, because we're talking about someone who has authority, the people of Washington, we're talking about the state of Washington, and then that delegation of a certain amount of authority. In agency law, the principal can take back that authority, but in Washington state, we have to get the legislature's permission to change our state constitution. Our state constitution sets out the scope of that authority. Anyway, if we get too much into state law, we're not going to get to local law. Okay. So I'll stop it there. Okay, so we've talked about states being, plenary power. The state legislature can do whatever it wants to do as long as it's not in the Constitution as a limitation on the state. And the federal government has its limited power. Where do local governments sit? Through the 19th century, well, let me back up. The U.S. Constitution doesn't talk about local governments. Those early state constitutions, many times didn't really discuss local governments. Often when people write constitutions, they write about the things that are important for them at the time, and they don't fix the systems that aren't broken. And at the time of the end of the 18th century, beginning of the 19th century, generally people weren't bothered by what local governments were doing. That whole American Revolution power struggle was about the relationship between the state legislatures and Great Britain and who could make those kinds of laws. So through the 19th century then, there was a lot of question, well, where do local governments sit? And there were generally two theories for local government power and kind of what lawmaking do local governments have. Please come in. We're kind of using this chart. So,
We can share.
So one of the theories for local government law was the right of local self-government. It's a very democratic idea. People govern themselves in the place where they live. And many judges said, well, yeah, there's a right to local self-government. It's inherent in the constitutional system. It's inherent in the structure of law that we adapted from Great Britain or we pulled in, and it's part of this constitutional framework. And so even though it doesn't have express statements in the constitutions of, well, the states, depending on the state, and the federal government, it's still part of our legal system. Another camp was an idea that, well, no, local governments are really just subordinate to the state government. they're like subdivisions of the state government. They only have whatever power the state has given them. They don't have power beyond that. State government is the principal, the local government is the agent, and there's a scope of authority delegated down to the local government. Right? Those two camps were in debate throughout the 19th century, even with the United States Supreme Court, sometimes saying that local governments, when they have a charter, are states within a state. There's a 1871 U.S. Supreme Court decision saying that. There were many states saying, well, yeah, the right to local self-government is part of this. There were other judges saying, whoa, we don't want to go there because of issues of local corruption and cronyism and all that stuff. And so we want to make sure that there is this delegated power theory. One of the judges leading that kind of theoretical camp is called Judge Dillon from Iowa. And the rule that we now live under is known as Dillon's rule. So I think I just kind of foreshadowed who won. But so, Judge Dillon's theory is that only the power that the state gives to local governments is the power that local governments have. They don't have any power to do anything other than what the state gives them. And by 1906, the U.S. Supreme Court generally agreed with this. In a case called Hunter versus Pittsburgh, which is still one of the kind of leading cases for this question of local government authority, the U.S. Supreme Court said local governments are children of the state. They only have the authority that the state has. The state has the authority to abolish them if it wanted to. The state has the authority to tell them basically to do whatever they want to do and all that. So if we think to modern times, the state of Michigan has, the legislature there has recently passed a rule that says the governor can abolish the elected bodies of local governments and institute an executive emergency manager, unelected basically. That's perfectly in line with Dillon's rule and Hunter versus Pittsburgh and this idea that local governments are simply children of the state.
Does it make any difference if the local government had their constitution and their set of laws in place before the state was even created? Or I was just thinking, like with the original 13 states, their constitutions were in place before the U.S. Constitution.
Yeah, I mean, at this point, we're not dealing with the U.S. Constitution. There's a case, Woodward versus Trustees of Dartmouth College from the U.S. Supreme Court, 1819, where Dartmouth College was around before, which state is it in? New Hampshire? New Hampshire. Dartmouth College was around before New Hampshire became a state, right? Dartmouth College was chartered by the King of England, right? So here it is, it's a corporation with a charter, and its charter is coming from the King of England. New Hampshire becomes a state. New Hampshire says, we would like some state higher education. So we're going to withdraw that charter from Dartmouth College and turn it into a state educational institution. The trustees of Dartmouth College say, no, we don't like that. We're the trustees of Dartmouth College, and we have our charter from the King of England. So in that case, the United States Supreme Court said that that charter was from basically the corporation Dartmouth College had is on par with the state. So part of that perhaps is because that charter came before New Hampshire became a state. And so there were kind of these two bodies that existed prior to New Hampshire actually giving the charter to Dartmouth College, because today, the authority to create a corporation comes from the state, right? So if you want to form a corporation or a business entity, you get permission from the state, and the state creates your articles of incorporation, like your business charter. And so it's an artificial person created by the state. But in that case, that charter came before New Hampshire existed. The state Supreme Court said the Dartmouth College and the state of New Hampshire, they're equals. They're partners, or equals like in a contracting situation, they're equals. And so the state can't just abolish Dartmouth College's charter. even though that case dealt with Dartmouth College existing before New Hampshire became a state, it's still used for this principle that the state doesn't really have the authority to abolish corporate charters. So once the state has given that corporation that charter, the corporation and the state kind of become equals in the eyes of the US Supreme Court. In Dartmouth College versus Woodward, or Woodward versus Trustees of Dartmouth College, I forget how the case is called, the US Supreme Court went on to say, but let's be clear, municipal corporations, otherwise known as cities or local governments, they do not rise up to that level of being peers of the state. They are always subordinate to the state. So even in 1819, the US Supreme
regardless
Court.
of when they were chartered or formed.
Yeah. So I think that's an instance of kind of wrestling with this. But a lot of times there's not very many cases on these issues. I may also just not know the cases that deal with that question.
It strikes me that in this, what you're talking about, Dartmouth versus Woodward, they were giving great priority to basically the King of England's charter versus a city's charter.
Yes.
Whatever. I mean, they were actually deferring to the king. It doesn't matter, but it's confusing.
So let's just take a straw poll. Dillon's rule or this right of local community self-government? Which would you choose if you had to choose one or the other system? Say you're the judge and you've got this local government saying, Your Honor, we have the power to create these laws, even if the state hasn't told us we have the power to, and you've got somebody else saying, Your Honor, only when the state authorizes local lawmaking can local governments make those kinds of laws. Which would you choose? Who would do the state authorization? The state has to authorize local governments to act, but for that authorization, no local action.
There's got to be uniformity of law, or it would be just chaos.
So uniformity, it's that patchwork regulation.
Right.
Yeah, we hear that a lot today.
I would have done that except for the reference that you gave earlier, which was Governor Walker,
Yeah.
who just said.
No, not Walker. That's Wisconsin. This
Oh.
is in
Michigan.
Michigan.
What's his face?
Saying, sorry, cities, we're taking away your city chart. Isn't that what you said?
Yeah.
Because they were bankrupt, or
It's
Well,
happened
one
to a
was
number of
right.
cities.
One
Yeah.
thing.
so I didn't like that.
Yeah. Yeah.
Other than that, I'd say yes, go with Dillon.
Yeah.
It seems really logical to me that the closer to the public that the government can be, the more likely you are to be able to control it and have some kind of an input. And I come back to the same thing that I said earlier. We probably are not, if we're not going to go with our county charter, since we are a chartered county, then we do need to move, because that is the authority that we are under here.
So you've got that other option, just to finish our straw poll, of local governments should be able to create laws without having to get state authorization to do that. Who thinks that? I haven't really spelled that out as well. But, okay, so a number of people as well.
I was a recent case in Texas that the legislature had overruled the city's right to disallow fracking.
Yeah.
It's a good example, I think, of the state taking over the will of the people in the cities.
And the state's able to do that because of Dillon's rule, right? Because
Let's do away with Dillon's rule. Everybody.
City of Denton said, we
Chaos
don't want
ensues.
fracking, and the state legislature in Texas very quickly said, oh, you can't do that, and set a law that very clearly said the authority to regulate oil and gas is held by the state. So there's a lot more we can say about that, for sure. So, at the end of the 19th century, there were several very large social movements in the United States, the populist movement, the progressive movement, and many people in the United States said they were not happy with Dillon's rule, right? So there was a movement against Dillon's rule, which was basically becoming the dominant theme within the courts. And one of the ideas within that movement was home rule. And the idea of home rule was that local governments can pass laws as long as they are not in conflict with the policies of the state. Right? So it attempted to liberate local governments from Dillon's rule, saying that local governments themselves have that plenary, broad power to pass whatever they want to further health, safety, and welfare, just like the state does. But if there's a conflict between the state law and the local law, state law trumps local law.
So if a local law is established and then the state comes in and creates something, if we already have our overruled thing, do we stay with that, or we have to go with the state then at that point?
It's the state. Yeah.
I lived in a city charter ruled city for many years. And I understood that if the city had a more stringent law and it's recorded, that would prevail over the state law.
Yeah. So it's going to depend on the state. Was that Washington?
Colorado.
In Colorado. Okay. So let's see. I'll continue with the history and I'll tie that in there. So many states, almost all states, passed. Well, the people of the states. Let's be clear about who's acting. The people of the states passed into their state constitutions amendments, often called home rule amendments. These amendments said basically that local governments, counties, cities, townships, sometimes even saying districts, can pass law without being preempted by, well, have the authority to pass law, and only if it's in conflict with state law does the state trump that local law. So it's expressly changing Dillon's rule in one respect, which is prior to the home rule amendments, local governments have to go to the state legislature and say, state legislature, we need to be able to pass this new law concerning fire codes. And the state legislature would say, we authorize this law concerning fire codes. And the local government would say, thanks very much. That was pretty cumbersome, and sometimes you have to wait 2 years or more. So it expressly dealt with that. But at the same time, home rule fits within Dillon's rule, because home rule is the state constitution, or the state, right, in a certain respect, authorizing this broad plenary local government power. Right? So the local government can pass whatever law furthers health, safety, and welfare as long as it is not in conflict with state law. So then we get, go ahead, Lucy.
So were they amending their state constitutions to clarify that?
Yeah, amending their state constitution. So to bring this specifically to Washington, Washington became a state pretty late in the 19th century. And the people who wrote the Washington Constitution specifically didn't have to amend it to put in home rule, but was one of the first states to put home rule for cities directly into the state constitution. So we had home rule for cities of a certain size or larger at the very beginning of our state constitution. In the 1940s, the people of Washington amended our state constitution to create home rule authority for counties, right? So cities had it from the very beginning of Washington state constitutional state government. And counties have had it since we, the people of Washington, amended our state constitution in the 1940s.
And that's why counties are so messed up.
Is it?
So that amendment was passed by the legislature to the Constitution.
I forget when the rules for amending the state constitution, but I imagine so. Yeah, I'd have to check that. Because it's possible the rules about how we amend the state constitution have changed over time, and I'm only thinking about the current ones, not.
Yeah.
So then we get into this question of, well, what's a conflict, right? So if a local government can create any law it wants, as long as it furthers health, safety, and welfare, and it's not in conflict with the state law, and also I'm ignoring in this conversation not violating somebody's constitutional rights, right? But that's always another limitation on what government can do. Then how do we decide what's a conflict? And this gets into preemption theory, which is one of the most heavily litigated parts of of constitutional law. It's really not very clear, even though it kind of should be. But so there's a couple different kinds of preemption. One kind of preemption is when the state legislature says, we preempt the field of X, right? Let's say tobacco regulation, right? Washington State Legislature says, we're passing a law, and this is the law on tobacco regulation in Washington. The local governments have no power to do anything other than this, right? That is field preemption, and it's express. It's expressly stated in the statute, and that basically prevents local governments from doing anything, right? Within that field. Then local governments can argue, well, we're not actually in the field of tobacco regulation, we're in the field of zoning, and it happens to intersect with tobacco regulation, and so we're allowed to do that, right? So you argue then, well, what's the field, and is what the local government does within that field that's been preempted, or outside of that field that's been preempted. Right? It's also possible to have implied field preemption. So the legislature hasn't expressly stated that it's going to preempt the field of that particular subject, but the courts find that the legislature has such a pervasive scheme of regulation that there really isn't any other room on the field for local law to get involved. So, it's like every seat is taken, and while the legislature didn't expressly say local governments can't play on this subject, basically because the statute is so extensive, it's clear that local governments have no place. What's a good example? A federal preemption, like aviation, like air traffic control, right? States don't really do anything with air traffic control as far as I'm aware. That's probably an area where the federal government can claim, implied preemption if it hasn't expressly preempted the field. So then the other, and I guess express preemption especially is relatively simple, even though there's these debates over what's in the field and what's not in the field. The other form of preemption is conflict preemption. And conflict is where the state law says you have to go left and the local law says you have to go right? Well, that's, you can't do both. You can't follow both the state law and the federal law. So one of them has to yield, and because of Dillon's rule, it's state government that trumps local law, right? Sometimes, though, conflict preemption is not as clear, and it's hard to know exactly, well, did the legislature intend to preempt this kind of local law, or did it not? And that's where the courts will then say, well, what's our test? What are we going to look at? And they'll say, generally, we're going to assume that local law is valid. We're going to assume that it's constitutional. We're going to assume that it was within the scope of the local government's power to enact. We're going to assume that it's not preempted until somebody proves otherwise. So that's the default position that judges who have to look at these questions of preemption use when they're analyzing preemption. That's kind of the standard of review, as we call it. So, can I borrow that?
Yes.
So preemption concerns local law, state law, federal law, right? If the federal government has preempted the field, then the states and local government can't act within that field. If the state government has preempted the field, then local government can't act within that area, right? So preemption is about this vertical interaction between government. We also have interaction between what I will call constitutional, legislative, and regulatory lawmaking, which is basically constitutional lawmaking is by the people, legislative lawmaking is by our elected representatives, the legislature, and regulatory lawmaking is by regulatory agencies. We could also talk about another kind of lawmaking, which is by the courts, where judges make opinions and that creates precedent, and then subsequent courts say, well, to be fair, we need to treat similarly situated people similarly, so we're going to follow that past precedent unless there's a good reason not but I did not put that judicially made common law onto this chart. So constitutional law by the people, that's where we're talking about often these very big structural issues. We're talking about what does government have the power to do? What does government not have the power to do? Government, who within government actually gets to do that? So we think about the federal constitution. It sets up, the executive, the legislative, the judicial branch. It talks about how those three interact. It then has this Bill of Rights, that kind of gentleman agreement. That's why there are a bunch of amendments. They got thrown in later. That sets out very clear limitations. Very clear. Ooh, I shouldn't have said they're very clear. They're not very clear at all. It sets out limitations on what government can actually do. State constitutions generally have the same framework, where they divide power up, and then they also say what state government cannot do. Washington, we have a Declaration of Rights. I should actually say the Declaration of Rights in state constitutions is usually first, and then the powers of government is after that. Of course, with the state constitution, if something isn't said as a limitation on government, then it's assumed that the state legislature has the power to do it. And if a power isn't assigned to the executive, then it's assumed that it's held by the legislature, because the state legislature inherited that power from the king in Parliament back in the 19th century. Even Washington's legislature did that, even though we weren't around at that time. So then getting a little bit more complex, and probably outside what we need to talk about for the charter, is the idea of regulatory law or administrative law. Sometimes the state legislature says, there's this topic that we know we need to pass some laws about, but it's really complex and technical and scientific, and we're a bunch of lawmakers, we're firefighters, we don't know how to regulate this area of technical law, right? So we are going to pass a law that says we want some regulation over this area of law, and we are going to give the power to set up the details of that regulation to an agency, to an administrative department of the government, which is usually the executive branch of government. So the state legislature, going back to agency law, the state legislature has the power to make laws in Washington. The state legislature takes some of that power and gives it to its agent, which in this case happens to be called an agency, and that agency then has power to make laws within that particular scope of lawmaking. It is an area that's pretty complex, because when we think about the three different branches of government, it's the executive branch that enforces the law, whereas the legislative branch makes the law. But when we talk about executive agencies, these administrative law, the legislature has taken its authority and given lawmaking authority over to the executive branch. So courts typically say you can only do that in certain situations, and it's got to be clear. You can't just the legislature can't say, we're tired of governing. Can we just give all of our government power over to the executive branch and they'll take care of it all? They can't do that. The courts will say, well, you can't do that. The people set up this three-part system, and it's the legislature that needs to make the laws, and the legislature can only delegate certain scope of lawmaking power to executive branch agencies. So that's where regulatory law comes in. Whenever you're dealing with regulatory law, you want to look for the statute, the law passed by the state legislature, and from there say, okay, well, what is the scope of power that this agency has, and then what does it do? So going to the local level, these three kinds of government lawmaking still apply, right? We're here in Clallam County talking about the Clallam County Home Rule Charter. The Clallam County Home Rule Charter is our local constitution. It is lawmaking by the people. We have the elected, basically, charter convention, constitutional convention going on right now in this very room, like Philadelphia, basically, although they're not going to shut the doors on people. And they're basically saying, well, what are the rules that we want for how our local government works, right? And then the legislative branch of our local government has to follow those rules. The executive branch of our local government has to follow those rules. This is, the Home Rule Charter is our constitutional limitations on our local government, delegating who has power to do what and saying what those limitations are. So I think that's a helpful way to think about the Home Rule Charter within this context. Even though the source of authority, we can debate whether, well, is it authorized by the state or is it inherent in the people and all of that stuff? That's all fun stuff. But ultimately, this is basically our local constitution. And then our commissioners are basically the local legislature. They're the ones creating local laws or ordinances, which are kind of the equivalent of state statutes. And within the framework of Home Rule, they have the power to create lawmaking as broad as the state, as long as it's not in conflict with the state's laws. And then in terms of local regulatory law, probably boards, maybe the planning board, stuff like that, kind of do that regulatory function. But since we're talking here about the constitutional end of things, I think we can probably ignore that more detailed thing.
So where does something like the minimum wage, where the state can have a certain threshold and cities and counties can go beyond, that's not really in conflict, but it would probably be illegal for a city or county to set a minimum wage lower than that of the state, right?
Yeah.
And I think that's true in a lot of aspects of labor law, where local jurisdiction can go above and beyond what the state.
Yeah. So, and this gets
That makes
into
sense.
more strict local regulations, right? So in Washington, our minimum wage law at the state level says that local law can go above the minimum wage. So we could pass in Clallam County a local minimum wage law, right? If we want our...
Whether or not we were a home rule.
Whether or not we were home rule, right? If we're home rule, we the people of Clallam County have the option of putting that into our charter, which locks it away from our our elected legislature, the county commissioners. But, or the county commissioners could pass it themselves, right? That's another, I think, important thing of, well, are we so sure that this policy that we want, or this rule that we want, should be locked away from the legislature's ability to change it? Or do we want the legislature to be able to change it? Sometimes as the people, we say, well, we don't want the legislature to be able to do a certain thing, and so we're going to put it in the Constitution, right? And sometimes then we say, well, gee, it would be nice if we could change that constitutional provision. Like in Washington, we have limitations in governments being able to loan money. And often, local governments or even the state government are like, oh, I wish we could kind of loan money. It would facilitate this project in this way. But people have said, no, you can't do that, right? In Washington, the state minimum wage allows local governments to act to go above the state established minimum wage, but obviously not below, right? In Oregon, the state's minimum wage law says the state law preempts local minimum wage law. So if a local government in Oregon wanted to raise its minimum wage, they would face pretty quickly a preemption claim that state law trumps that local law. And this gets into the issue of well, what is a conflict, right? So is state law that says minimum wage must be, what's the current minimum wage in Washington? Let's say $10. State law says $10 minimum wage. Local law says, where do people want minimum wage at? $15 minimum wage. Is there a conflict between those two laws? Could you, as an employer, follow both of those laws? No, why not?
Sure.
If you're paying somebody $15, are you also paying them at least $10? Right, yeah. So you can comply with both laws. You can meet the state minimum wage and you can meet the local minimum wage. So there's not a conflict between those two laws. So So the only way for state preemption to stop the minimum wage from going up would be if the state legislature expressly said local governments can't do minimum wage, right? Because there's no implied conflict. Now, if the local government said employers can't pay people more than $10 an hour, which would be an interesting law. Well, then it's like, well, the state says you have to pay more, and the local government says you have to pay less. You can't comply with both laws, so there's a conflict. Right. So that's kind of where the more strict idea comes in. That local governments can create more strict regulations, but not necessarily weaker regulations.
I don't know, I'm going to play devil's advocate on it because, of course, wage laws are sensitive issues and people have a lot of irrational things on that. But back in Colorado, one of the issues that went to court was the state law had a certain density for development. The city, Charter Right City said, no, we want it much less dense. So actually it was the reverse of what the argument would be on the wage laws. And they would have won, except they hadn't recorded it in their master plan.
The city.
Right. And that's the thing is, even in the wage laws, if the city had it recorded with the particular reasons why they go, let's say $9, wouldn't that still prevail because they've given the reasons?
So, let's see. There's a few things going on in that example, and it is a really good example. One is Colorado and Washington. Home rule in Colorado is very different. I mean, I can't just like remember home rule off every state, but Colorado is one I know a little bit about. And in Colorado, anything that is purely local, the local government still has power to act on without being preempted by the state. So if that municipality was able to say to the judge, hey, look, this is a purely local law, this doesn't affect anything outside of our boundary, then it's immune from state preemption. So it's possible that that was at play. Washington does not have that part of home rule. So we don't have a purely local laws are immune from state preemption part of our home rule. Colorado is one of the states that does. And then it's also possible that, you know, what is more protection, what is stricter might, I mean, if you could twist it around, you could say, well, less dense is more protective, maybe people's home values, you know, so we get into this question of, well, what is more protection and what is less protection? You know, more protection for whom or less protection for whom? And so it depends on how well you're able to ultimately argue which is the more protective law if it's not really clear which one preempts. So that's a challenge. And we have to look into the details more. But I'm not surprised that they potentially would have won with that. Also because with conflict and preemption law, you often can kind of get to whatever result the judge wants to get to depending on what options are available, which is often the case in law too.
Sure.
So with our home rule charter, you know, we're thinking about it as a constitution, right? It sets limits on the rest of the county government. Whatever we put in the home rule charter, the commissioners can't touch. Right? They can't change those boundaries that we set up for them. We set up this structure and they have to work within it. That could be good, that could be bad, depending on what we're dealing with, right? We're also dealing with it within the context of state law and federal law, and this idea that if it is in direct conflict with state law or federal law, that state or federal law prevails. So, you know, the courts will make an effort when dealing with the conflict challenge to try to harmonize the local law with the other law, but if it just can't be harmonized, then the local law loses over the state or federal law. There's a lot of other theories, but really when we're getting into kind of the structure of government that we deal with in the Home Rule Charter, a lot of it ends up becoming political theory. You know, how many people can best make decisions in a legislative body. And I don't know what the best answer to that is, and the law doesn't provide an answer to that. Those become political theory questions for us as a community to wrestle with and decide. So in some parts of the charter, there is a question of, well, we were talking in the lobby before we started about whether Washington state law authorizes a local government to create grand juries, or whether only the superior courts can call a grand jury. And we have to look at the state statute and decide, well, what does that state statute say? Does it stop us from doing this action, or could we, right? So it is very important to consult the applicable state law, but on many questions, it's also a question of what we prefer as a community and how our government works. So I just want to throw that out at the end of, a lot of these questions are questions for us as a community to decide, and there's not a right answer coming from lawyers or judges or the law itself. Any other questions?
I had a question that was referring back to here, just to understand. So the county board of commissioners are seen as the legislative branch of our government and not the enforcers of whatever legislation they pass.
So typically in legal theory, going back to the 17th century, I think with, was it Montesquieu, who's the philosopher who set up this idea of branches of government, we separate the judicial branch interpreting the law from the legislative branch that makes the law from the executive branch that enforces the law, with the idea that that separation of power diffuses power. And in federal government and state government, we do those three separate branches. In local government, the way we have it set up now, the commissioners are both the legislative branch who make the law and the executive branch who enforce the law.
Okay, so
They
That's
do
true
both.
in many cities as well.
Yeah, that's true in a lot of local governments.
But they tend to delegate it to their administrator in our state. A lot of their executive, they delegate.
Yeah. So, and this is an important thing. I know the Charter Review Commission is thinking about these particular issues. So this is a spot where public input for the commission would be great. About how do we wrestle with this theory of, well, should the same people be making the law and enforcing the law? Is that fine? Or do we want to separate that?
On the grand jury question that you were talking about in the lobby, what was the verdict? I mean, is there state guidance of any kind on the matter of the grand jury?
I don't know offhand, but we'll look it up.
I just looked at it today. And it's clearly set out that the Superior Court is authorized to call a grand jury. And it's laid out how that's to be done and what's. Now, the question is, which I didn't get to today because I didn't get the charter law today as laid out in the Constitution, is what does the state say the charter can do in relationship to this kind of effort, of doing it. And there's other counties, I think, in the state that do have grand juries.
Not in our state.
But not in our state, yeah. And so it's an area I have particular interest in. And so right now, I can't answer that question. I don't know if anybody's looked at that part of it to see what it's allowable that we can move outside, even with the charter, if we can move outside and create a grand jury system outside of the one the state has established for the whole state.
Well, and to add to that, does that state statute say that Superior Court judges and only Superior Court judges can create grand juries? Or could is there that authority and then there could be more authority? So we have to actually get into the language of it and kind of tease it apart from thinking about a preemption and what creates a conflict sort of perspective. I'll take, there's a question in the back, question here, and a question here.
Since I came in late, this may have been asked already. You touched on the role of the commissioners as executive and enforcer or legislative and some, two roles. We have, much of our leadership is elected, and Commissioner McIntyre has said that there's a body of law that says considerable body cannot interfere with another elected official's duties. So how can they enforce the charter and what the rules are supposed to be? They're doing their job. How can that be enforced?
So I'll go back to history to try and answer that, and it will be an incomplete answer, and I apologize. When the progressives and populists who set up Washington government, they were really afraid of concentrated power. They were afraid of corporations, right? They were afraid of corporations having a lot of power in society. And so they tried to make sure that there wasn't just all the power in the state legislature. And they tried to diffuse power in different ways. One of the ways that they tried to do that was to have multiple elected officials, right? So we elect our state governor, who's executive branch, but we also elect his lawyer, right? The attorney general, right? He doesn't get to choose his own lawyer. Like, we elect his lawyer for him, or her. And so, we elect multiple different executive officers with the idea that it diffuses power and makes it harder for, a kind of single executive to control the whole executive branch. We do the same thing in Clallam County with multiple elected officials.
That they have no power.
Well, now over 100 years later, 125 years later, we are in a situation where, like, well, what does this actually mean when two elected officials disagree, and how do they resolve it? So that's not going to answer the question of, well, what power do they have to interact? But the policy is there that these are multiple elected officials who are there as agents of the people, with the idea that it diffuses power in a way that at least the theorists back at the end of the 19th century thought would help to ensure more accountability in government. Whether it works, I don't know. We're here in Clallam County to find out, right?
With an informed electorate, it would work.
With an informed electorate. Well, that's always the hope, right? There was a question
I
here.
just wondered if you knew, if you could speak to why there's only a handful of counties in Washington that have gone to the home rule charter.
Yeah, so the question, there's 39 counties in Washington, and I believe only 7 have home rule charters. Most of those have been the big population counties. Clallam County was one of the first rural counties. I mean, I grew up here, but I thought I grew up in a city because I'm from the city of Port Angeles. And then I go to college, and my roommate's from Houston, and I'm like, oh, that's what a city is. So rural county, and we have, we have a charter, and now a few other smaller counties do as well. It's hard to do. It requires this process. But ask folks from Jefferson County. Well, I guess I could point any direction from Jefferson County. Ask folks from Jefferson County who recently decided not to do a charter, right? And I think part of it was, that people said, well, boy, the political ideas that I like could be advanced through a charter, but the political ideas that people I don't like could be advanced through a charter too. And I'm more afraid of that than I am of my ideas going forward. So they voted it down. They decided, let's not elect a board of freeholders and create a charter. They said, no, we don't even want to start that process. So it's a democratic tool. I mean, it is a law created by the people. And this fall, we are all going to vote on rearranging, potentially, depending on if the Charter Review Commission decides to put anything forward for an amendment, but we'll vote on rearranging the fundamental structure of our local government. And hey, democracy, but that's also kind of outside any individual's control as well. So, I don't know. Talk to folks from Jefferson County about why they voted it down.
So what's the legislative part of Jefferson County? Commissioners?
Yeah, so they're going to use the default rules given by the state statutes rather than creating their own set of rules.
Okay.
It's almost like when you download software, you're like, go with the default package, right? And then you get that. But you could also customize it, which is what the charter allows us to do. You had a question?
I lost my thought.
I'm sorry.
That's okay. I should have written it down.
So it's 6:10. In about 20 minutes, the Charter Review Commission is going to start and take public comments. And I really encourage people to share comments and feel empowered to share your ideas about the political process and how it should work here in our county. Keeping in mind that we're talking about a constitution, ideally dealing with the structure and limitations on government and those kind of big picture concept ideas. But also, it's a space for us as people to create law local to our charter. So thank you so much for participating.
Before we end, would you give the camera your contact information again and name?
Sure. Okay, so I'm Lindsey Schromen-Wawrin. You can reach me at 360-406-4321, or my email is Lindsey, L-A-N-D-S-E-Y, at world.oberlin, O-B-E-R-L-I-N, @.edu. All right, thanks.